In this class, we will discuss regarding mahr or dower as under Islamic law. So, before discussing the very definition of mahr or dower as in Islamic law, we'll analyze the very historical background of the development of mahr or dower. So, in the pre-Islamic Arabia, two forms of marriage prevailed. So, one is the Beena Form and the second one is Baal Form. So, in the Beena Form, the wife on marriage did not accompany her husband to his home but continued to remain in her own home where the husband visited her. In this form, it was customary to give on marriage a gift to the wife. This gift is known as sadaq, and in the other form known as Baal Form of marriage, the wife after marriage accompanied her husband to the matrimonial home set up by him, and the husband, in consideration of wife's leaving her parents' home, paid some amount to her parents, and this amount is known as mahr. And when Islam spread in Arabia, the Prophet reformed the law of marriage, combining both sadaq and mahr by Prophet Muhammad. He reformed the marriage from the bride purchase notion. Sadaq-mahar, mahr became a sort of marriage settlement where the amount was not paid to the wali or guardian in marriage but to the bride herself. So, regarding that, we'll discuss that mahr is something in the nature of nuptial gift which a Muslim undertakes to make to the wife. It is inherent in the Muslim concept of marriage. In this sense, mahr is an integral part of Muslim marriage. And as regarding definition, how Mullah, one of the eminent authority on Islamic law, defines it as a sum of money or other property which the wife is entitled to receive from the husband in consideration of marriage. And Justice Mahmod, in the leading case, Abdull Kadir versus Salima in 1886, explained that mahr has been compared to the price in contract of sale because marriage is a civil contract and sale is a typical contract to which Muslim jurists are accustomed to refer to by way of analogy. And Abdur Rahim defines it as he correctly and successfully defines it as mahr is either a sum of money or other form of property to which the wife becomes entitled by marriage. It is not a consideration proceedings from the husband for the contract of marriage, but it is an obligation imposed by law on the husband as a mark of respect for the wife, as is evident from the fact that non-specification of dower at the time of marriage does not affect the validity of marriage. So, Ameer Ali divided the very position of mahr as he fixed that the mahr by mutual consent after the marriage is known as mahr-i-tafwees, and when the amount is settled by arbitrators or the judges, it is known as mahr-i-takkin. So, the very amount of mahr may be increased after the marriage. Such is the importance of mahr in Muslim law of marriage that a stipulation in the contract of marriage before its solemnization that the wife abandons all her rights to dower is invalid and inoperative, and the wife will be nevertheless entitled to proper dower. But a wife who has attained puberty may remit the whole or part of the amount of dower in favor of her husband or husband's heir. So, next we will discuss regarding the very concept regarding quantum of mahr.